My name is Nikki Parr. I'm the Associate Director for Strategic Initiatives at Women's Economic Ventures. And we have restarted our WEV Works webinar series after a week off last week. So welcome everybody that can join us, and welcome to those of you that are joining us later. So this morning we will be talking about a subject that WEV traditionally hasn't approached very much during its trainings. We're very good at helping people launch, and we're very good at helping people grow, but today we're actually going to be talking about what happens on the other side of that, when you feel like you may be thinking about closing your business, or you may be in a position with creditors that is compromising your success, and what is going to be the best way for you to resolve that without compromising your own personal assets too much, and really, how do you do this in a constructive and thoughtful and measured way, and really we're trying to give you facts this morning. So as I said in my kind of email that went out earlier this week, we feel that knowledge is power. We want you to be able to make the best decisions for you and to give you that information in a way that's clear, to enable you to do so. So long-winded way of saying this morning we're talking about bankruptcy and closing, not necessarily bankruptcy, but reorganizing your business. And we are going to be joined this morning by William Beall, who is our local expert in bankruptcy. He's a bankruptcy attorney practicing in Santa Barbara. And he is going to share his wisdom and his knowledge with you all. So, well, over to you.
Well, thanks, Nikki. Hi, everybody. I'll just tell you a little tiny bit about myself to start with. I grew up in the LA area a long time ago. I like to joke it's before electricity. That's a joke, but in fact, it was before the personal computer that I became a lawyer. We kind of have grown with the technology. After getting educated all over the country and working for some tremendously large firms that hated me and I hated them, I ended up marrying a woman from Santa Barbara who suggested we moved up here in 1982, and I've been here ever since, working on bankruptcy law, helping people as best I can. So I've been doing it a long time. That gives me some institutional knowledge. And what we're talking about today is, obviously that I don't need to tell you, this pandemic has caused problems for many, 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 many businesses. And some of the problems are significant and some of the problems are way worse than significant. So what we're talking about is, what happens if your creditors are barking at you, if you need some help with what's going to go on, especially after you're able to reopen, or if you've been open up, get up to full capacity again. And we want to talk about those issues in the context of what you can do, how you can protect yourself, how you can keep your business going if it's worth going, and shut it down in a way that causes the least pain to yourself if that's what has to happen. So Nick, you want to give us the first slide here and we'll talk about some things? Nikki's muted, so we can't hear the cursing that she's doing while she tries to figure this out. But we've all done this. I don't know about you, but I was talking to Nikki before we started. I've been Zooming with my 93-year-old father, and everybody's got different devices going on, and people are doing it on their phone or some, different things depending on what's got microphones. If we have to go,
I'm trying to find it. Let me just, I'll just plug away in the background. You can talk while I try and find it.
Okay. So let's talk first about how you do business, because a lot of your alternatives, both in terms of reorganization and in terms of liquidation, are different depending upon what your form of business is. And we have main forms. The main one, of course, is to be a sole proprietor. In that case, your business and you personally are the same entity. You are, so if I'm a small business myself, I could be William Beall, attorney at law, and doing business, and that's just all one entity. So that's a sole proprietorship, and that's one of the main ways I'm sure that many of you do business. There are other types that are of entities that one might use. You could do an S corporation. You could do a C corporation. S corporations pass through taxes directly to their shareholders. C corporations get taxed at the corporate level. You'll probably rarely be a C corp, I would think. But also you could be a partnership. Maybe you have two or more of you that have joined and made a partnership, or you could be a limited liability company, an LLC. And that's and so you'll go ahead and advance that, Nikki. Thanks. And these are all different entities that one might use to do business in. And I'm going to kind of lump the corporation, partnership, LLC ones together as we go forward, because most of the rules are the same for them. And then the sole proprietorship's a little bit different, and we'll talk about that as we go through. So you'll want to focus especially on however you do business, and then let's talk about that. So yeah, we're frozen on the first slide, says somebody in the chat. Let's get to slide 3, okay? If you can do that, Nikki. I'm not sure if you can advance it. Just you can go over to the left and click on it.
I'm advancing it. Is it not sharing?
Yeah, all we're seeing is the first one.
Okay, I apologize. Let me see if
That's
I can
all right.
relaunch it and start again. Hang on.
So as we go through, let's talk about the different kinds of debts that you might have, because different kinds of debts have different approaches in how you deal with them, either in a reorganization or in a liquidation. So the first kind of debt is leasehold debt. Of course, many people, as we all know, have been not paying their rent because they can't. And there's different rules. I actually saw in my news this morning that the city of Santa Barbara, if you happen to be in the city, has just passed something saying you're going to get a year to catch up on leasehold payments that may have been deferred during the pandemic. So that's, but a lot of people are behind on leasehold payments, and that's going to be true maybe for if you rent your house as well as if you rent a business space. Then we got accounts payable. These are your vendors. Depending on what you do, they sell you the raw products that you use to make your product, or sometimes they just sell you the paper and staples. And if you're a restaurant, it's always Giordano's, these kind of folks. Next, we have lenders, and the lenders can be all kinds of things. They can be banks. The banks often take security interest in your assets. They could be these PPP loans that we're having going on, and we get a lot of that. Of course, I'm sure the PPP loans, the ones that aren't forgiven, and my understanding is they're going to come due in 2 years. So anything I'm telling you about those is going to be very early. And then we have taxes. And the taxes split in all kinds of different categories as well. You have income taxes. Well, the good news is if you're having bad times at your business, typically you're not making a lot of profit, you don't owe a lot of taxes. But sometimes the other kinds of tax obligations can get after you. You owe payroll taxes, you owe sales taxes, and these things can have their own special rules. And we'll talk about those as we go through. Now let's go ahead and advance that. So first we're going to talk about what happens if you can reorganize your business. And reorganizing means that we come up with a plan to pay back creditors over time. And that may be in full or in part. Some creditors get paid in full, some creditors can be paid in part depending on the rules. There are at least 3 chapters of the Bankruptcy Code that provide reorganization abilities for small and smallish businesses. They're chapter 13, chapter 12, and we have a new subchapter of chapter 11, which has just come into law in February. So this is now another option that we're allowed in terms of reorganizing small business debt in bankruptcy cases. Let's go ahead and advance that. And let's talk about chapter 13 first. Chapter 13 of the reorganization chapters is often the best option, but it is limited to individuals. And when I say individuals, I'm not talking about Antonin Scalia and Citizens United. That means people, okay? And so if you do business as an LLC, as a partnership, as a corporation, you cannot file Chapter 13. But if you're a sole proprietorship, then, as I said, your business and yourself are one entity, and this is a good option for you. Chapter 13 has debt limits. You can only owe $400,000, $419,275. I got the number there on the slide. It's a funny number because it goes up by, you know, the cost of living over the years. And then you can have up to $1.2 million of secured. And what that usually means in Santa Barbara is you can have one house but not two. As soon as you get to a second house in Santa Barbara, you tend to be over that $1.2 million secured debt, and then we have to seek other chapters. Chapter 13, we provide payment over time, we make a plan, and we pay certain debts in full, and we pay other debts sometimes in part. And the debts we have to pay in full are the secured debts, and the debts we can pay in part are the unsecured debts, usually. The tax debts often have to be paid in full, but not always if they're old enough or the right kind of tax debt. There's different kinds of tax debts, but those can be paid in part. And a Chapter 13 plan, we propose a plan that is regular payments from a 3 to 5 year period. Often, of course, we're using 5 because we want to stretch it out as much as we're allowed to and reduce the amount of the monthly payment as much as we can. I'm usually able to pay unsecured debts without interest. I'm often able to cure secured debts without interest on the cure amount. So if you're 4 or 5 mortgage payments behind, we can get those caught up over a 5-year period of time. Tax debts, again, often without interest, usually in full, and that's a Chapter 13 plan. We kind of figure out how much you owe, what you have to pay, and then go forward. The rules on how to figure out how much we have to pay on unsecured debt we'll get to in a minute after I talk about other chapters. Let's go on to Chapter 12. Chapter 12 is a reorganization that is only available to farmers or fishermen. I don't know if that applies to anybody here. It's a good tool if you happen to be a farmer or a fisherman. The debt limit, again, is up a little over $4 million. The definition of family farmer and fisherman means that at least half your debts and half your income have to come from farming or, of course, fishing. And it's a similar type of plan. It is available to corporations, LLCs, partnerships, other entities that are not eligible for Chapter 13, so sometimes available there. Chapter 12 has historically not been very available in the Central Coast because our land is so expensive that when we have land owned by farmers, their debt tends to be over $4 million. But I have had a couple of fishermen cases over the years, and there are some small farming entities that can qualify for Chapter 12, even in the Central Coast. Let's go on and talk about Chapter 11. Chapter 11, small business. Again, we're talking debt, again, limited to $2 million and such. Again, all entities can use it. Payments over 3 to 5 years. I haven't done one of these yet, which is surprising. I've done many larger Chapter 11s, but this subchapter 5's only been part of the law since February. We're a little unsure about exactly how much of the other machinery that is part of Chapter 11. Chapter 11 is made for, United Airlines, Sears, and although we can file it for anybody, it often has a lot of stuff involved in it that makes it very difficult for a very small business. But hopefully they're streamlining these subchapter 5 cases so that we can make them work for smaller entities. And again, we're talking about the possibility of paying unsecured creditors in part. Let's go back and talk about the different kinds of entities. Let's talk about leases. Leases are a special category in any kind of reorganization case. If you have a lease, you have to either assume it or reject it. Assuming means that you have to do the following things. You have to cure promptly any default on the lease. Nobody knows what prompt means. Obviously, I think in a post-pandemic world, the judges out there are going to be more flexible in terms of what is a prompt cure. The landlord's entitled to demand adequate assurances of future performance, which often means you give a pro forma, you give a projection of your business income going forward, which says, look, Mr. Landlord, here's what I'm going to do. Here's how I'm going to be able to pay my regular payment and pay you enough on the back to catch up those lease payments I'm behind. If you don't want your lease, you can reject the lease. So part of a reorganization case might be getting out from under a large leasehold obligation that you may no longer want. You may say, well, gosh, here I'm renting this lovely State Street office, but I found out I can work pretty well from home and run my business. But I've got 5-year lease on my State Street property. And you want to, now you say, and my property's $4,000 a month. You do that by 5 years, and you're talking, that's 4,040. We're talking $240,000. Did I get that right? Maybe, or and sometimes I miss a zero. Anyway, but it's a big number, and it might well be your biggest single debt is your leasehold obligation going forward. In bankruptcy, essentially, a landlord is never able to get a claim that is more than a year of prospective lease. They can get their back payments plus a year more of rent, but that may be considerably less than you owe on your lease. And sometimes getting out of your lease is an attractive reason to do a reorganization case. Let's go to lenders. Some lenders are your mother, your brother, your friend that has, and those people that have just, given you $25,000, $50,000 to help you get your business going. They're treated just like your vendors, just like regular trade debt. They're general unsecured creditors. Sometimes you've gone off to Montecito Bank and Trust and gotten yourself an SBA loan, and now you're dealing with Montecito and you're dealing with the SBA, and they have likely kept a security interest in all your assets. Now, your business assets may be less valuable than the amount of the debt, especially when you look at them at a liquidation value. So they may be a partly secured and a partly unsecured creditor. And so you may owe $50,000 on a business loan, but the collateral for the loan is only worth $10,000. So now we actually have a double debt. The bank is owed $10,000 as a secured lender that has to be paid in full, often with interest, and $40,000 as an unsecured creditor, and that goes off and gets treated with your vendors and any other lenders you have. And that's called a bifurcation of your secured debt, and it could be a useful tool. The secured debts get paid with interest. Oh, I'm sorry, interest. I made a typo on that slide, my bad. Also, a lot of times you're going to have another secured creditor, which is your home loan, especially if you're a sole proprietorship. Remember, your personal situation and your business situation are one entity, and you may be behind payments on your home loan. Home loans are have a specific category in all reorganization debts. They're given a special thing. They're very difficult to bifurcate. You can only do it under very certain circumstances. Essentially, you have to have a second trust deed that is completely unsecured, that the first is more than the amount of your house. We saw that a lot in 2009 and 10. We're not seeing it very much anymore. Property values have recovered enough that we're better there. Let's go on to taxes. we have all kinds of different taxes, and we have income taxes, as I talked about. Payroll and sales taxes have a special category because payroll and sales taxes are taxes you collect that you don't really pay. Or, well, some payroll taxes you do pay, but a lot of them you don't. You take them out of your employees' paychecks. Sales taxes you collect from your customers. And the taxing entities, whether that's the state or the federal government, they take it very badly if you have collected taxes from somebody else and then not paid them over. And those taxes basically never go away in bankruptcy. Income taxes do, but they have to be older. And the older income taxes, more than 3 years old, they become unsecured debts, and again, treated like trade debt. More recent income taxes, along with the payroll and sales taxes, are typical priority taxes. Those we have to pay in full in various reorganization chapters. Let's look at the secured issue. So now we have a whole bunch of different things that now create your unsecured class of creditors. We have vendors, we may have lenders that don't have security interests. We may have lenders that have part security interests. We may have some old taxes. So, and of course, when I talk about your vendors, then we got, again, in a sole proprietorship case, we've got your personal vendors as well. And those are your credit cards often. Almost everybody has credit card debt, especially as you try to keep your business going. That credit card debt has a tendency to rise. In reorganization chapters, we can pay those in full or in part. And the in part thing, we have a couple of rules we have to meet. And the two rules that are most important, there are others, is that the first, you have to make your best efforts to pay your creditors back over a period of time. So whether you're in chapter 13 or chapter 11 or chapter 12, you do a pro forma, you do a projection, and we look at what you're going to do for the next 5 years. And then we sit there and we say, okay, over 5 years, I can make this much money. So I need to devote that to paying my debts, to catching up my lease, to paying my priority taxes, to paying my secured debt. What's left over, that goes to my unsecured creditors. We have to use our best efforts to pay them. Obviously, since we're doing the pro forma, we have some ability to work with that number. The next number is the best interests of creditors test, and that is, we have to look at what would happen if you liquidated. If you liquidate yourself, do your creditors get paid? Do they get paid in full? Do they get paid in part? And a reorganization case always has to pay creditors as much as they would have received if there was a liquidation. Now, before we talk about liquidation, that actually brings us to the most important question that you have to look at when you're looking at these things. Do I have the ability to reorganize, or am I really thinking about liquidating? And that really is a two-part question. The first is your business viable going forward? In my opinion, if you have a business that is making money from today onward, you should always look at your ability to reorganize. No matter how much back debt you have, your business is got at least the potential of being worth saving. So the accumulation of back debt is something that bankruptcy or reorganization cases is extremely good at working with. Now, sometimes, of course, you have the ability to both liquidate and continue in business. And that's especially true if you're a sole proprietorship. So that might be an option as well, where you say, well, I'm liquidating in the sense that I'm not going to pay my debts back, but after I'm done with that, I'm going to just go back to going into business. So you take somebody like me who practices law. If for whatever reason I had to liquidate and file a Chapter 7 bankruptcy case, it isn't like I have to give up my license to practice law. I just start practicing law again. It's a new sole proprietorship in essence. So that's a possibility as well. So that's the sort of gives you the broad brush version of what happens in a reorganization case. Let's talk about a liquidation case. So in liquidation, you can go ahead and advance that, Nikki. In a liquidation case, that's usually Chapter 7 of the Bankruptcy Code. What happens is a trustee in bankruptcy gets appointed, and the trustee's job is to take personal assets, and that of course may include business assets if your business is sole proprietorship, and reduce them to cash, pay your creditors to the extent they could be paid, and then you get discharged of your debts. Now, they don't take all your assets and you don't get all your debts discharged, and that's where the interesting things are. The discharge of debts, again, we talked about secured debts. A secured creditor has an ability to look to the asset. So I can discharge a car loan, but in doing that, I have to give the creditor the car. So I either have to pay for the car by paying off that car loan, or I have to give up the car, and that's usually an option. Same with your mortgage on your house. And again, remember, you may have a bank loan, a PPP loan, other types of loans that have security in your business assets, in your inventory, in your accounts receivable, and even in your desk and your all that kind of stuff. And that we may have to deal with that in a liquidation case. There are certain kinds of debts that don't discharge. We talked a little bit about tax debts. Largely, they don't discharge. They can to some degree. There are debts that you may owe an ex-spouse that don't discharge. If you owe student loans, they're very difficult to discharge, sometimes can be discharged. Other kinds of things. If you happen to have hit somebody with your car while you're drunk driving, if you've committed a fraud on people, that there are bad things that you might have done that do not permit discharge of debts, but most debts do discharge. And that's, your credit cards go away, your vendors go away. That stuff's usually pretty easy. Property. Let's talk about what assets you might have that might be subject to liquidation by a trustee in bankruptcy. Well, we talked about the house. Many people in Santa Barbara, if you own a home, you may have tremendous amount of equity in it, and that's very important. You can protect some equity in a house. The equity is protected by something called a homestead exemption, and that goes from between about $50,000 and $175,000, depending upon your personal characteristics. Are you single? Are you married? Are you head of household? How old are you? But you may have a homestead exemption. Now, a homestead exemption of $100,000, that would be typical for a married couple or any other head of household. That would cover a house in many places, but it doesn't cover the equity that many people have in their house in Santa Barbara. So we have to always be very careful to look at that. And that's the homestead exemption is an exemption. That's the first one I wanted to talk about because it's the most important. But there are two sets of exemptions, and you can choose between them. The first set of exemptions is what we call the state exemptions, although they're both in the state law. This is historical only. And that includes that homestead exemption and some other exemptions for things like moderate value of a car. Your most pension plans are exempt, IRAs, simple plans, 401ks, that sort of thing. And then there's some other specific exemptions, your clothes and stuff like that nobody's too interested in. And also some tools of the trade, which is often enough to protect, whatever it is, the stuff you have in your office. Then if you do not have a house, then you are usually able to take the other set of exemptions, which usually has the same specific exemptions as the state exemptions. We call them the federal, but they're in the state law. And then the federal exemptions also include an exemption of about $30,000 of any property that you want to protect, which is often useful for protecting maybe some business inventory, some cash you have in the bank, maybe your car's worth more than the car exemption, stuff like that. So sometimes the exemptions are the property that you get to keep that the trustee is not allowed to take away from you. So you may be able to say, I'm doing business as a sole proprietorship, look, here's what I've got. I don't own a home. I'm a renter. All my business property added up is worth less than $30,000. So you don't get to take anything from me. I can just file a bankruptcy case and walk away from my old debts, or from many of them, and then start over with my sole proprietorship next week, doing what I do and hopefully doing it well. So those are those are the options in Chapter 7. And again, it is easier in many ways to deal with this in a sole proprietorship. And the reason for that is because if you have let's say you got an LLC, then the LLC membership interest is an asset that you have. Now, that's not a problem in a personal case, because it probably, if you're looking at liquidating, your LLC membership interest is not a very valuable asset. But the debts occur at the LLC level, and to get out of those debts at the LLC level, you may have to actually get rid of the LLC and start business as a new LLC after you file a bankruptcy case. And that might be a challenge in a number of ways. Setting up that transfer from the one case to the next can be difficult. And all I can suggest is that if you think you're going to want to do something like that, make sure you get good legal advice before you set out to do anything. And I'm not talking about legal advice you're hearing from some disembodied voice over the internet. I'm talking about go in and talk to a lawyer that is your lawyer and working with you on your situation. Let's talk about some non-bankruptcy alternatives, because these are completely available. I mean, of course, we have credit counseling. Credit counseling works best for credit cards. Some of your vendors might be willing to work with a credit counseling plan as well. There are two kinds of credit counselors. There's nonprofit ones. They set you up on payment plans. And then there's for-profit ones. They try to buy out your debts at discounts. And they're both perfectly reasonable ways of going about things. The alternatives are there. And then there's just negotiating with your creditors. A lot of creditors are going to be very generous with people, because everybody knows that everybody's having terrible, terrible times in this pandemic world. And the problem you're going to have with some of your vendors, I'm sure, is that they're in at least as bad a trouble as you are. And they need you to pay them so that they can save their business. And that leads them to be rather shrill sometimes and very difficult to negotiate with. And you just have to understand that it's because they're in trouble too. So that's an important thing to remember when you're talking with your people. In dealing with creditors will accept discounts. They will also put you on long payout programs, sometimes both. But it's always good to remember that cash talks, so that a creditor that you owe, $20,000 to might take $7,500 today, or put you on a payment plan where you pay $17,000 over a period of time. You almost always can get out more cheaply if you can do it more quickly. Let's talk next about when should you be taking time. When should you be hearing what you should do? Well, first of all, advice is always a good time. It's always time to get advice, because if you go in and talk to somebody like me that understands this process and can tailor their advice to your personal situation as opposed to the generalized stuff I've been saying today, then you'll have an idea what you can do. That may help you negotiate with creditors, because you can go to a creditor and go, look, if I go out of business, you get nothing. Instead, I can give you a half. Do you want to take that? And knowing what you can accomplish is a useful goal in terms of that negotiation. The other thing is, let's talk about what happens when the bad stuff happens. And we've got foreclosure on your house, repossession of your car, eviction from either your personal or business premises, lawsuits, That's legal action. Now, right now, pretty much all of that is stopped. Nobody can foreclose on a Fannie Mae or Freddie Mac loan for right now. Theoretically, the other loans you can foreclose on, but the lenders won't foreclose on those either, because right now, the civil code requires any kind of foreclosure to be a public auction. And under stay-at-home rules in the state of California, we can't have a public auction. So the title company won't insure your title if you go hold a foreclosure sale right now. So that's just dead in the water as of right now. Evictions, completely dead. There's a moratorium against evictions in the state of California generally, I believe. Certainly in the city of Santa Barbara, as I just got extended, and the city passed a law saying you get a year to make up any back payments. So it's going to be a while before that's going to come home to roost, which is a good thing. Lawsuits, it's very difficult to start a lawsuit right now. The superior courts are closed completely except for emergency hearings. So you've got a little bit of space on these things. That doesn't mean when our society reopens that this stuff isn't going to happen. It is going to happen. And creditors that are owed money are going to start lawsuits. Landlords are going to start eviction proceedings. They're going to give 3-day notices. Secured lenders are going to start giving foreclosure notices or go back to the sales that they've had teed up. So these are all the things that are going to happen. These are the things, bankruptcy stops all of these things. Reorganization cases stop them usually permanently, at least if you can reorganize the debts appropriately. Liquidation cases stop them at least temporarily. And so this is a time when, if you're looking at your house being foreclosed upon, that's when you need to file before that happens, especially if you have $500,000 or $1 million of equity in your home, as many people in Santa Barbara do. You don't want to lose that because you've been asleep at the wheel and you say to yourself, my goodness, what can I possibly do about this? I'm just under siege. So that gives you some idea of when it's time to be talking about some stuff. And I kind of been running really fast. I'm sure many people have lots of questions and I've been going too fast to answer, but maybe we can take questions. I don't know, what do you think?
Absolutely, let's open it up. We've got quite a few that are in already in the question and answer box, and okay. I just encourage you to type in questions if you have them. We have Will's expertise at our fingertips right now, so make the most of it. So Will, I mean, I can read these out to you. So leases in Santa Barbara, we can start payments 1 year, or it's deferred and split over 12 months.
It depends on the kind of loan. Okay, so what I saw this morning, and again, I just read a NewsHawk article on something the city council did yesterday, apparently. And my understanding is that it is even payments over the next year to catch up back rent payments. That's what I understood. But again, I haven't seen the text of the, what do the city council pass? Ordinance, I guess. I haven't seen it, but that's what I understood from the article I read in the press today. I would hope that landlords will be flexible, especially residential landlords. I mean, if they throw you out of your house or your condo, what are they going to do? The next tenant isn't going to pay the back rent, and all that's true for business property as well. So they have an incentive to work with you, and this negotiation you would hope you could do at least as well as the city ordinance that just got passed. But there is something in the city now that permits this for a year.
And where would you recommend to find that exact wording? Would that be something that's on the City of Santa Barbara website, or where would that be posted?
I would think it would be. Also, one thing that's better in the city than it's been is that we all now have a dedicated city council person since we've gone to a district situation. And I would encourage anybody to call their personal city council person and say, hey, I'm in your district, I'm your constituent, tell me about this. Send me a copy of the ordinance, and your city council person should be happy to do that.
Okay. Do you think there will be new legislation that protects commercial tenants from needing to pay 1+ years of whatever's left on the lease if we need to close our business due to COVID?
You know, that's also up in the air. With this PPP stuff, every time I turn around, they're adding new requirements and things like that. It seems to me that we're going to need more help. That I saw that $2 trillion, and as we know, that got everybody through what, a month or 6 weeks of paying their employees. I mean, it wasn't enough. And so there's going to need to be rules. The banks have been agreeing to forbear 3 mortgage payments. What are they going to do when they get to the end of that 90 days? Are they going to modify those loans? Are they going to create a streamlined modification process so that one doesn't have to do the nightmare that's modification currently? Who knows? It's all up in the air. We're going to have, well, we just saw a city pass. We county laws. We may have state laws. We may have federal laws. None of it's happened yet, but I think we have hope that there's going to be relief given to people. The trouble is, of course, that every time this happens, we just push the problem around. So when tenants don't pay rent, then landlords can't pay their mortgages, and they can't pay their mortgages, then banks have problems. So we all understand this is an issue, and the legislators at every different level of government are going to be dealing with this, trying to figure out how to help people from this and get our economy back on the footing it was.
Yeah. Okay, this is a multi-part question. So leasehold obligation, missed something. Did you say that the landlord can claim back owed plus 1 year forward on a long-term lease?
In a Chapter 11, 12, if you're reorganizing a debt and you're dumping the lease, you're saying, I'm out. Okay, the claim is going to be for whatever back you owed plus typically a year going forward. So if you're 3 months behind, it might be a 15-month rent claim. Now, you may be able to pay that at 10 cents on the dollar or at 5 cents on the dollar. And if you're filing Chapter 7, it may be completely discharged. But that's the way that at least you don't have a 10 or a 20-year lease payment claim being added, especially if you might have assets that are such that you have to pay your claims in full. Again, if you've got a house with $1 million of equity in it, now all of a sudden you find that your house is sort of on the line for your business lease, and you hadn't really realized that.
And so leading on, doesn't a bankruptcy put the lease at the bottom of the list of creditors? If you have the secured creditors and the unsecured creditors, where is a lease obligation unsecured, or is it?
If you want to continue your lease, then it pops up to a priority situation where you have to pay it and you have to cure, unless you can make a deal with the landlord. Once again, you'd hope that the landlord would make a deal with you. But if you're getting rid of your lease, it goes down to the unsecured claim, the general unsecured claims, which is as it goes.
Mm-hmm. And just finally on this question, how does this play out in COVID with the eviction moratorium? Might it be wise for a landlord to release an unstable tenant from the lease rather than allow them to squat while digging a deeper hole of debt owed?
Yeah, landlords have been doing that forever, and one would expect they will continue to. In fact, you know, in the residential world, there's a, quote, cash for keys, close quote thing, where, you know, the landlord might pay you to leave so he doesn't have to go through the eviction process. And you know, whether you're going to see that in the commercial world, I see actually the fallout from this COVID thing. I see commercial landlords as being perhaps the most hard hit category, because one thing is, we've all found that we can work from home. Yes, it's not as good, but we can do things here. So that means we'll all need less space down there at, you know, and does that mean 2 lawyers sharing one office where one works at home Monday, Wednesday, Friday? Does it mean giving up your office permanently? But I think the commercial landlords are going to, and of course they've been having a terrible time on State Street anyway with the retail. And now the upstairs is going to be affected as well as the downstairs storefronts. I think they're going to have a very challenging time.
Yeah, good point. And so here's a question from Jill, and she has a business that's just off of State Street. She says, the only way I foresee my business surviving is if our entire rental rate is lowered. We're off of State Street and our rent is crazy expensive and will only be able to run at a limited capacity for the foreseeable future. Any tips on negotiating? If it's not lowered long-term, we'll have to close the business permanently.
Yeah. And I, how do, again, the idea that I always think in these sort of negotiations, it's useful to come talk to somebody like me. And then you can go back to the landlord and go, well, I talked to Will Bell and he says that if I got to leave, you get nothing. I just think it's a useful thing. Whether it's true or not, frankly. I mean, I don't lie, but that doesn't mean you can't if you're negotiating with your landlord. The thing is that I have seen landlords have been extremely reluctant to reduce rents over the years. And sometimes I don't understand the economic reasons for that. They must have them. I don't know what they are, but you see the empty storefronts on State Street and you kind of go, well, why isn't the landlord reducing the rent and getting somebody in there? But then they go, well, but then the guy I'd get in would be more of a fly-by-night. I don't know. They seem to be resistant to that. Again, one would hope that you could have a successful negotiation, but it's going to be really landlord specific. Some of them are going to be a lot easier to deal with than others.
Yeah. Here's a great question and something that I'd written. What are the long-term repercussions of bankruptcy or liquidation or reorganizing? You've talked about lots of different concepts. So I think what people are often concerned that their credit history gets wiped and they're back at at the beginning. So can you just talk about what are the long-term repercussions? What are the consequences?
Well, there's no doubt that you take a credit hit and your credit score is going to get knocked down. And you gotta fix it. And there's certain kinds of debts that you won't be eligible for a while. Though in my experience, those things come back pretty quickly. Depending on a home lender, you may be able to get a home loan within a couple of years after bankruptcy. Now, a lot of it's got to do with what you look like afterwards. Have you filed, you got rid of something, now you've started over, and how's your business look now? Does it look successful? In my experience, lenders looking at somebody who has a past bankruptcy says, well, you have a bankruptcy, I'm not lending to you because they don't like the loan. Or they say, have your lawyer write me a letter about why you filed this case. Then he's papered his file so that now your loan officer can say, oh, yeah, now I looked at it, I got an answer, now I can lend to you. So it's a convenient excuse for them if they don't want to make the loan. Again, that's part of it. Some kinds of debts are too easy to get afterwards. You're going to see, solicitations for credit cards almost as soon as you're out of bankruptcy. And there's certain kinds of, you can get a secured credit card and start rebuilding credit. Maybe you maintained a car loan through your case, just something, because every time you make a payment as agreed, your credit score goes up by a little bit. And frankly, if it gets knocked down, every time you make a payment, it goes up by more. So somebody with an 800 credit score, if they make their payment on time, FICO says, well, of course, we expected you to, but somebody with a $600 600 FICO score, every time they make a payment, it increases a little more. So it is possible to rebuild credit. Frankly, I've always kind of wondered, are you a better credit risk if you filed a bankruptcy, or are you a better credit risk if you have a million debts still sitting out there? But I'm not sure creditors always look at it like that.
And just to kind of put a bit more of a specific timeline, 2 years, 5 years, or does it really just depend on,
Depends on what you're looking to do. Yeah.
Okay.
A year or two for many home loans. Other home lenders will say, no, you had a bankruptcy, I won't lend you for 7 or 10. But, a car loan you can get immediately after bankruptcy, but car loans go, you got your credit union rate, you got your bank rate, and then you're up to, your household finance and those kind of rates. And right after bankruptcy, you're at the household finance, 15% interest. After a while, you can get back down and get into that credit union rate. Credit unions are a special category. Typically, a credit union, if they've ever suffered a loss because of you, they won't lend you again. But if they haven't, they're like, well, you know, we'll find a way around it.
Sure. And so earlier you talked about how it's easier for sole proprietors to just kind of file and start again, you know, almost the next day potentially. But is there something to do with the bankruptcy that would preclude you from getting a lease, for example?
You know, again, a landlord's going to do a credit report, or at least a larger landlord will. And frankly, this is something that I've seen in the personal world as well. So if you go to a landlord that's got 1,000 units and you want to rent a unit, they run a credit report on you, and if they don't like the idea you filed a bankruptcy case, they may not rent to you. But if you go to somebody who's got 1 or 2 or 3 units, you know, they're looking at you more, and they often don't even run a credit report, and you got a much better chance. You know, it seems to me that people that are residential tenants, I mean, there's not that many residential tenants that are tremendous credit risks. Well, heck, we got people renting for $20,000 a month here in Santa Barbara. So, I mean, I'm not talking about those people. I'm talking about the people who are looking to rent condos for, you know, at minimal rental values. It's difficult in this town. But again, it could be a problem, especially if you go to one of the larger agencies. And I think the same thing might be true when you go to business landlords. It just depends on who the landlord is. It depends on who they are. You know, we're talking about different landlords. My personal landlord, my office is in the La Arcata building. That's the 1100 block estate. And our landlord is just an absolute sweetheart. And, you know, she looks at you as if you're you. And but I know others are not quite as pleasant.
Yeah, that's a great point. And so Lynn we love Lynn at WEV. She's fabulous and takes care of a number of our clients. So, and sort of relating to this, Kimberly asks, what if I have a personal guarantee on my lease? And I'm thinking, Kimberly, you're asking, and you want to get out of that lease. How does having a personal guarantee impact your ability to quit a lease?
Right, and then so that means, okay, so if you have a personal guarantee on a lease, now all of a sudden, so obviously you have some sort of a business entity, let's call it an LLC, but it doesn't really matter whether it's a corporation. What that means is that now your problem exists not only at the LLC level, it exists at the personal level, because if your LLC goes out of business, the landlord has the right to just come to you personally. And that might mean that you have to think about filing a personal bankruptcy case if you cannot pay your business lease to get rid of the guarantee. The personal liquidation case is actually a significant problem when you have a business failure, because a lot of debts are guaranteed. I should have talked about this earlier. A lot of people guarantee their lease. That big bank loan that you got, or even if it's not a big bank loan, if you went to Union Bank or you went to Montecito Bank and Trust and took out a loan, they often get a guarantee. Plus some of those tax debts, you didn't realize there's a personal guarantee, but if you owe payroll taxes, if you owe sales taxes, those come right through your business entity to you personally. At least the trust fund portions of them do. So they may cause you to have a personal financial situation that is on top of your business financial situation, and you may have to think about 2 cases, or maybe you just drop your business and don't even, I mean, sometimes you don't even have to file for the business. The problem is actually all at the personal level while you start a new LLC to restart your business. So these are all possibilities.
Yeah. And Pam, I think in a related question, if you have a personal guarantee for leases, commercial and equipment, is there any way to protect your house? And I think that you were just addressing that point, but it's very specific to how much equity you have in your house.
Yeah, that's the most important thing. If you're under the homestead exemption, you're fine. If you're over it, you're typically not. But again, if you had a lease liability and that came to you personally, that might be a time where a bankruptcy case might be able to at least reduce down the lease liability to where you were able to reorganize it through a Chapter 13, not on the business level, but on the personal level, that might be something that would be a possibility.
Okay, great, thank you. Zidania asks, what are priority taxes, please?
So typically the priority taxes got to do with how old they are. An income tax that is due 3 years or less ago. So right now we're 2020. So 2016 income taxes were due April 15th of 2017. 3 years from that, it was April 15th of 2020. So if you did not get an extension on your 2016 taxes, they are now non-priority, they're dischargeable taxes. But if you did get an extension on your 2016 taxes, then they weren't due till October 15th. And so your 2015 taxes are non-priority, but your 2016 taxes are still priority, as well as 17, 18, and 19. That's just income taxes. There's slightly different rules on the other types of taxes that I'd be happy to go through if it's important on an individual basis with somebody if they want to talk to me about it.
Okay. How do you get an equipment lease company to negotiate?
Yeah, I mean, you know, it's sometimes those guys are, wow, you know, and you go, really? You really want to take back? I had this printer one time, and there was this huge copy machine, you know, that we owed a ton of money on, and it was worth absolute junk if they took it back. And those guys would not make a deal with us no matter what. We ended up fighting them and litigating and having a full day trial, and then they appealed, and I mean, it was crazy. And you're like, what are you thinking? You want this? And not only was literally the it's just a huge 5-color printing press thing, right? It was worth less than the cost of moving it because the thing was so big, and those guys would not negotiate, not at all. And I don't know. I mean, you kind of wonder, is it a matter of principle with them? Are they being badly represented? You just never know. Now, all I can say is you hope you don't get those guys again. But I mean, because equipment, I've had those issues with the equipment lessors, let me tell you.
So no hints and tips there. It's just
well there's all kinds of stuff
out.
Too, because equipment leases are interesting because usually they're not really leases. They're really sales contracts, but the lessors really try hard to make them look like leases. And a lot of times we've had fights about whether they're really conditional sales contracts or whether they really are leases. And I've fought that, and then I fought that, and I won it for years, and then those darn lenders went around behind my back, and they went to the legislatures of all 50 states, and they passed changes to the Uniform Commercial Code, which let them win a lot more often. You stick around the law long enough, and you go, oh, well, you stole the march on me that time. You can still get around them and sometimes make them conditional sales contracts, but it's a lot harder than it used to be.
Oof. Right, going back into some very specific. I bought my business in December from the previous owner for $220,000, 20% down, the rest of payments spread out over 6 years. I'm currently in repayment to her. It's likely that if I can even reopen, my business will not be viable for some time. If I liquidate, what are my obligations to her in repayment?
And again, one of the biggest questions there is, did you give a security interest in the business assets? What are those business assets, and can they be replaced? Because, and one of the business assets, of course, is a subtle one, and that's the quote business goodwill, which might mean the name of the business. It might mean the website, the phone number. Now, most creditors have zero interest in those assets for these small businesses. But the one creditor who might care about that is the person that sold you the business, because they might be in a position to actually take back over and call their, I did business under that name before, I can do it again. So that's a specific business goodwill issue that occurs with the prior owner of the business. I'll tell you these things. Maybe in a COVID world, this will be a little different. When I see these fights between the ex-owner and the new owner, unfortunately, they can become kind of mudslinging contests, because what happens is often the old owner says, "You're not paying me," and the new owner says, "Yeah, that's because you lied to me about how good the business was, you know, what I was able to do with the business. The financials you gave me were fraudulent." And then that turns into a very nasty lawsuit. I wouldn't want to suggest that you use that as a tool, and especially when your problems are COVID related, that may not be the case at all. But if you're having problems with the seller of the business, it might be worthwhile looking at the business financials they gave you during your due diligence period.
Okay. Okay, another commercial leases. They aside from payroll, those are the biggest expenses, I think, for many of us. So, so my commercial lease ends on December the 16th, 2020. Since I'll not be able to open my store until maybe October, do I have to pay all the back rent since I'll only have use of the building for 2 months, or should I just move all my inventory out? Well, you have a lease obligation there.
Yeah, I mean, and there, you know, there's an interesting question. And of course, you know what it's going to come down to is, do you want to stay? Because when you get to December, you know, it's a normal thing to do, to talk to your landlord and say, well, shall we extend the lease, sign a new lease, and here's what I think we can do under this new lease, or, you know, and can we roll in the back rent? How about if we, you know, increase the rent by a little bit to pay for, you know, the amount you lost over time? This is all a negotiation that you can have. Frankly, the fact that you got to have a negotiation with your landlord about what's going to happen after December is a sensible time to have a conversation about what's going to happen until December.
Yeah, and she doesn't want to stay. So yeah, that probably will, yeah. There's the answer.
Well, but again, and you may be able to stay for at least a while because of all these moratoria, perhaps. I don't know the plural moratorium. And I think moratoria is right. Anyway, and so that you may have a little bit of time to figure out what you want to do before you bring the truck in and bring out your inventory.
Here's a direct question, and you can choose to answer or not, or give a politics answer. What is your hourly rate if people want to see you privately after this?
Yeah, so
it depends.
Okay. So first of all, my hourly rate's $525, which I know is just making everybody faint. But partly that's because I'm a super specialist. I have, you know, and ideally I spend much less time on issues than many other people. But in fact, a lot of these bankruptcy cases are done on a flat fee basis. So anytime we do a Chapter 7 liquidation case or a Chapter 13 case, we say the hourly rate is not important at all or only important in certain circumstances, and we will do a case for X dollars. It typically runs a couple of $1,000s to do a Chapter 7 case, maybe more like $5,000 to do a Chapter 13. The Chapter 13 fee is often paid over time as part, or a chunk of it anyway, as part of the payments that one makes under Chapter 13. That might be true also of a 12 or an 11, excuse me. So all I can suggest is almost all lawyers will give you an hour, a half an hour of time for free without charging you. So do not ever be concerned about hourly rate in terms of getting a consultation, because you may find that that although you can't afford the hourly rate, you can't afford the case that you need.
Yeah, excellent advice. Can you go into more detail regarding asset protection in Chapter 7? Which categories of liquid assets are protected? A health savings account, ? And can you explain the $30,000 exemption? Thank you.
Sure. So and again, this is the $30,000 exemption is almost exclusively for non-homeowners. homeowners that don't have any equity in their house or very, very little might also be able to use it, but we're thinking non-homeowners now. So it's just $30,000 of anything you want. So if you've got, you know, $10,000 in the bank, fine. That HSA, the health savings account, that's an interesting question. I actually haven't looked at that issue. It seems like something that should have an exemption attached to it, but I'm not aware of one right now. I'd have to look. I just don't know that right off the top of my head. It's kind of surprising you stumped me on that one, but I don't know. The other things, a lot of your liquid assets are what you use that $30,000 for, because the illiquid assets, you know, you got a bunch of inventory. You know, your inventory, you may have spent $5,000 on it. It may be worth $10,000 if you can sell it at retail over goodness knows how long. But in terms of a liquidation, it might be worth $1,500 because that sort of stuff's very difficult to sell. So we can usually use the liquidation value in a Chapter 7 in terms of using that $30,000 up. 30,000 isn't the exact number, by the way. It's 29 something something. Anyway, I forget exactly. I didn't look that one up before we got going today.
All right. So just a couple more comments / questions. Katie just shared that she filed a bankruptcy in 2010 and since then has secured 3 commercial leases and never been turned down for one that she applied for. So I think that's excellent information.
Well, and that does raise one question that's very kind of an interesting thing. So everybody filed bankruptcy in 2010, didn't they? I mean, that's what I remember. I was in practice then. I mean, those were bad times. I'm kind of being flippant and I shouldn't be. But one thing is, one can only file a Chapter 7 case. The rules are a little different on other chapters, once every 8 years. And actually, that's a relevant number because of that 2010, we had a massive bulge in filings. And so many people did file in 2010. And so those people are now eligible to refile. And something else that comes up from Casey's comment is, you know, when we talked about what are the effects going forward of having filed a bankruptcy case, I think after 2010, when people, you know, were looking for loans in 2011, 12, 13, and somebody said, well, what happened to you in 2010? People went and said, well, what happened to everybody in 2010? And I got a feeling when we get to 2023 and somebody says, well, what happened to you in 2020? Everybody's going to say, well, the pandemic happened to me. And I think that that's going to get you, if not a free pass, it's going to go a long way towards one. But we'll see. That's a world we're not to yet.
Right, exactly. But there has been precedent, yeah. And then one final question about priority taxes. I recently found out that my accountant didn't send in my 2012 to 2015 income tax reports. As they said they had done, the IRS assessed penalties because they'd not received the reports. Are these back taxes considered priority taxes?
Oh, well. So there's a line in the movie Groundhog Day where Bill Murray says to this nice lady that runs the bed and breakfast, did you want to talk about the weather or are you making chit chat? Because that question about the non-filed taxes, I could give you a half an hour on that one. It's an interesting thing, but let's just say it gets really complicated. And one of the super complications of that one is, did the IRS file what's called an SFR, a substitute for return from you, before you got the back taxes filed? And whether they did or not, the whole story diverges. So it gets real interesting, because if you have an SFR, things get a lot more complicated. That one, I mean, it's a very, very specific little issue. I would suggest, you know, you call and we talk about that offline, just because, again, there are different rules for priority taxes. And so technically those ones that are non-filed make them I have to look. They're, you can discharge them in Chapter 13, but they're non-dischargeable in Chapter 7. There's 4 rules on dischargeability of taxes, and the failure to file is one of them, and it's different in 13. I just have to make sure I'm not saying the wrong thing about that when I tell you about it.
Okay. Yeah, that's very, very specific. So I think a good one to take offline if you need the definitive answer. So I think we don't have any more questions, but I'm going to put it out there, people. This is, you know, you've got Will's expertise and knowledge. And I guess, you know, what I'd say is I hope this has helped just clarify that bankruptcy is just, or liquidation or reorganization is just, can be a very straightforward process, and that there's light at the end of the tunnel. I think, Will, I'd love you to just speak to, when we were exchanging emails last week, you said, oh, you know, I just do this, you know, all the time, right, and it's normal for me. And I think, you know, just to kind of emphasize for small business owners that are out there that may be totally freaked out at the idea of a bankruptcy or a reorganization or filing Chapter 7, 11, 13, whichever one it is, and is so scared of that process, if you can just speak again to life goes on, you know.
Yeah, no, that's absolutely right. I mean, look, these are very, very, very bad times, and people are going to have to do things that they don't want to do in order to make their business survive. I mean, everybody wants to pay their vendors. Heck, those people have been great to you over the years. You know, you've helped them, they've helped you. We all get it. But frankly, you know, if we can keep your business going, that there's value there, and if the only way to do that is through some sort of reorganization, whether it's official or unofficial, well, that's all good. This is not the end of the world. I mean, one doesn't want to do it. Of course, we try to avoid it, whatever we do. But on the other hand, there's reasons for these laws. When you look at the reason that everybody all over the world wants to do business in the United States, this is one of the reasons, because one can have a business failure and it isn't the end of you, whereas it is in many other parts of the world. These laws are there to protect you. They're there exactly for these sorts of situations. And this is a no-fault deal here. We all get it. Everybody knows that. And you just have to look at what you can do, what protects you, what saves your family, what saves your business. How can you make it going forward so that you can do the best you can for your creditors and for yourself? Again, you know, if you're having these sorts of difficulties, get advice. You know, I'm in town. There's other lawyers in town that are available to speak to you that will help you through these processes. You can figure out if it's something you want to do, or no, you don't want to do. Something you need to do, something that would be helpful to you going forward. It isn't the end of the world, you know, and you're not treated like a pariah. You know, it's not like you see those old political, you know, cartoons, political cartoons where the guy's wearing a barrel and he's got the bankrupt. I mean, it's not like that. It's not a demeaning process. And anyway, you know, again, it can't hurt to get advice. If you think you need it, feel free to do so.
Great. Thank you. There you have it. And I just again want to say thank you to Will for taking the time to be with us this morning and to share his wisdom and expertise. And thank you for participating in the webinar as attendees and with your questions. And again, WEV is here to support you. Will is here to support you. So if you have questions, just email me after the webinar, and we will be sending out a recording of this webinar. And Will, are you happy for us to share the slides as well?
Oh, sure, of course.
Yeah, so those will go out to with contact information. So again, thank you, and enjoy the rest of your day. Thank you, Will.
Thanks very much. Pleasure.
Okay, bye.
Bye-bye.